Fidelma, let's give you an opportunity to respond to this, if you'd like.
There's much that can be said, and there's certainly much that can be said on the contingency fee issue. To make it clear where that stands, this contingency fee issue was raised by to the trial court in Rhode Island, which rejected it. And in a very interesting recent bit of litigation, Sherwin-Williams Company in the Ohio cases, there are about 10 cities in Ohio that have filed these lead cases, and Sherwin-Williams decided that instead of litigating this contingency fee issue through the trial court, what they would do is they would go to federal court and file their own preemptive action. They filed for a preliminary and a permanent injunction, and after hearing on that, the federal district court in the Southern District of Ohio rejected these contingency fee arguments, and they did it for the same reason that happened in Rhode Island, as well as reasons that this same argument has been rejected in other litigation. There's public policy reasons behind it. When you deal with a public nuisance that is so widespread, and you deal with companies that are much more willing to spend their resources litigating and defending the cases, apparently with unlimited resources to do so, instead of becoming a solution, you end up with a very inequitable playing field because, for example, in the Rhode Island litigation, there were 122 defense counsel of record in the case. That doesn't include all of the paralegals and all of the other attorneys who worked for the defendants who never entered their appearance in the case but worked on it. When you compare that to the resources of the Attorney General's office, which has less than 20 attorneys in its civil division dealing with all of the civil cases, it's very clear to see what that inequity is. There were other issues as well that have been raised. The issue that the Southern District of Ohio focused on is this isn't a constitutional issue. No defendant has a constitutional right to choose who the state retains and the conditions under which the state retains someone. And the contracts as they're drafted make it very clear who retains control and who is the client in this litigation, who gets to make the decisions. So we've heard it today from a couple of different people, these wild theories about, you know, these poor government attorneys who've been bamboozled and have no idea what's going on, and while contingency fee attorneys run amok, and that's far from the reality. And courts that are looking at the reality see that this is an appropriate use of resources, and it's an appropriate to allow government entities to make their own decisions about how they would like to retain attorneys who represent them.